Hi everyone, welcome to Lawyer Up by NDV Law. I am Attorney Karlo Nicolas, a senior partner of Nicolas and the Vega Law offices. Today we are going to discuss about what is Syndicated Estafa under Philippine law. Let's first tackle the definition and legal basis of Syndicated Estafa in Philippine law. The crime of Syndicated Estafa is a different crime, different from the simple crime of estafa. Syndicated estafa is punished under Presidential Decree number 1689, while simple estafa is punished under Article 315 of Act number 3815 or the Revised Penal Code of the Philippines. The crime, known as syndicated estafa, is set and penalized by Section 1 of PD 1689. The section reads, Section 1, any person or persons who shall commit estafa or other forms of swindling as defined under Article 315 and 316 of the Revised Penal Code as amended shall be punished by life imprisonment to death if the swindling or estafa is committed by a syndicate consisting of 5 or more persons formed with the intention of carrying out the unlawful or illegal act, transaction, enterprise, or scheme, and the defraudation results in the misappropriation of money contributed by stockholders or members of rural banks, cooperatives, samahang nayon, or farmers associations, or of funds solicited by corporations or associations from the general public. So in essence, syndicated estafa is but the commission of any kind of simple estafa under Article 315 of the Revised Penal Code, including other forms of swindling in the Philippines, with 2 additional conditions. Namely, the estafa or swindling was perpetrated by a syndicate, and the estafa or swindling resulted in the misappropriation of money contributed by stockholders or members of rural banks, cooperatives, samahang nayons, farmers associations, or of funds solicited by corporations or associations from the general public. Now, the Supreme Court, in the recent case of Remo versus Secretary of Justice Devanadera, GR number 192925, dated December 9, 2016, the Supreme Court detailed the elements of syndicated estafa as follows. Estafa or other forms of swindling, as defined under the Revised Penal Code, is committed as follows. The estafa or swindling is committed by a syndicate, and the defraudation results in the misappropriation of monies contributed by stockholders or members of rural banks, cooperatives, samahang nayon, farmers associations, or of funds solicited by corporations, associations, and others from the general public. What is considered a syndicate? As stated in the definition of the Supreme Court, in order to commit the crime of syndicated estafa, the estafa must have been committed by a syndicate as contemplated by law. Under PD 1689, the term syndicate is defined as consisting of 5 or more persons formed with the intention of carrying out the unlawful or illegal transaction, enterprise, or scheme. This definition is somewhat vague. That is why the term syndicate has been elucidated by the Supreme Court. In order to be considered as a syndicate under PD 1689, the perpetrators of an estafa must not only be comprised of at least 5 individuals, they must also have used the association that they formed, managed, or constructed to defraud its own stockholders, members, or depositors. Only those who form or manage associations that receive contributions from the general public who misappropriated the contributions can be liable and commit syndicated estafa. Now, the court was able to come up with the following standards by which a group of swindlers may be considered a syndicate under PD 1689. They must be at least 5 in number. That is the first. Second, they must have formed or managed a rural bank, cooperative, samahang nayon, farmers association, or any other corporation or association that solicits funds from the general public. They formed or managed such association with the intention of carrying out an unlawful or illegal act, transaction, enterprise, or scheme. For example, they used the very association that they formed or managed as the means to defraud its own stockholders, members, or depositors. Now, what again is the penalty for this very, very great crime of syndicated estafa? The penalty for syndicated estafa under PD 1689 is significantly heavier than that of simple estafa under Article 315 of the Revised Penal Code of the Philippines. The penalty imposable for simple estafa follows the schedule under the article, which is amended by Republic Act 10951 and is basically dependent on the value of damage or prejudice caused by the perpetrator to the offended parties. Syndicated estafa, however, is punishable by life imprisonment to death, regardless of the value of the damage or prejudice caused. We have now discussed about what is syndicated estafa under Philippine law. If this video has been helpful to you, kindly hit that subscribe button. Kindly also visit our Facebook page and our website, ndvlaw.com, for a wealth of legal resources. Again, this is Attorney Karlo Nicolas of Nicolas and Vega Law Offices, and thank you for watching Lawyer Up by NDV Law.